class, I will discuss the right to constitutional remedy guaranteed under Article 32. Mere declaration of fundamental right in the Constitution is meaningless and worthless without providing effective machinery for their enforcement when they are violated. Means the right granted without mechanism for enforcement is mere eye-washing. The right to seek constitutional remedies attains significance if no provision had been provided as provided under Article 32 for enforcement of fundamental rights. Then entire framework of the fundamental rights would have been ineffective and incomplete. Article 32 confers remedies for the enforcement of fundamental rights of aggrieved citizens. Article 32 itself is a fundamental right and it provides that a person can move the Supreme Court by appropriate proceeding for the enforcement of the fundamental rights if they are violated, and this article shall not be suspended during national emergency. Article 32 empowers the Supreme Court to issue orders, directions and prerogative writs for the enforcement of fundamental rights. Regarding writ jurisdiction, High Court and Supreme Court stand on same foot. Means under Article 226, which empower the High Court to issue orders, directions and prerogative writs for the enforcement of fundamental rights. However, during national emergency, President can suspend this article, that is Article 226. These writs are 5 kinds. They are writ of habeas corpus, writ of mandamus, writ of quo warranto, writ of prohibition and certiorari. The first one is habeas corpus. The word habeas corpus literally means to have a body. This writ is an order calling upon the person who has been detained wrongfully. It directs the person so detained to be brought before it to examine the legality of his detention, and the detaining authority should present the detained person before the court and justify his detention. If the court concludes that the detention was unlawful, then it directs the person to be released immediately. Student, we have to know the circumstances of unlawful detention. First one, the detention was not done in accordance with the procedure laid down. For instance, the person was not produced before a magistrate within 24 hours of his arrest. The person was arrested when he did not violate any law. An arrest made under a law that is unconstitutional. However, habeas corpus cannot be granted when a person has been arrested under an order from the competent court. In Sunil Batra versus Delhi administration case, an application was made to the Supreme Court through a letter written by a co-convict on maltreatment of the prisoners. Supreme Court taken up this letter, treated it as a writ petition and issued the writ of habeas corpus, stating that this writ cannot only be used against illegal arrest of the prisoner, but also his protection against any maltreatment or inhuman behavior by the detaining authorities. Next one is writ of mandamus. Mandamus means it is a command issued by the court to a public official asking him to perform his official duties that he has failed to perform or refused to perform. Cannot be enforced by any other legal remedy. Therefore, writ of habeas corpus is a wakening call for the authority. It wakes up the sleeping authorities to perform the entrusted duties. Mandamus thus demands an activity and sets the authority in action. It can be issued against public body, a corporation, an inferior court, a tribunal or government to perform public duty or to perform. This writ order is issued on the following grounds: that the petitioner has a legal right, there is an infringement of legal right of the petitioner, the infringement due to non-performance of the duty by the public authority which ought to perform. Next, that the petition has demanded the performance of the legal duty by the public authority and the authority has refused to perform the same. There has been no effective alternative legal remedy. Writ of mandamus cannot be issued against a private individual or body, and when a public authority owes duty which is discretionary in nature to enforce contractual obligations against the President of India, Governor and Chief Justice of the High Court. The next one is writ of quo warranto means by what authority or warrant. This writ, the court calls upon a person holding a public office to show under what authority he holds that office. It is found that the person is not entitled to hold that office, he may be ousted from it. Its object is to prevent a person from holding an office he is not entitled to. Therefore, preventing usurpation of any public office. It cannot be issued with respect to a private office. Hence, it prevents illegal usurpation of public office by a person. This writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the constitution. It cannot be issued against private office. Unlike other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. The writ can be issued only when the following conditions are fulfilled. The public office is wrongfully assumed by the private person. The office was created by the constitution or law, and the person holding the office is not qualified to hold the office under the constitution or law. The term of the public office must be of a permanent nature. The nature of duties arising from the office must be public. The next one writ is writ of certiorari, that means to certify. Certiorari is a curative writ when the court is of the opinion that a lower court or a tribunal has passed an order which is beyond the power or committed an error of law, then through this writ of certiorari it may transfer the case to itself or squash the order passed by the lower court or tribunal. A writ of certiorari is issued by the Supreme Court or High Courts to the subordinate courts or tribunal in the following circumstances. When a subordinate court acts without jurisdiction or by assuming jurisdiction when it does not exist, or when the subordinate court acts in excess of its by way of overstepping or crossing the limits of jurisdiction, or when a subordinate court acts in flagrant disregard of law or rules of procedure, or when a subordinate court acts in violation of principle of natural justice where there is no procedure specified. The object of both certiorari and prohibition is to make sure that the lower courts or tribunals exercise their powers properly and that it does not usurp the jurisdiction when it does not possess. The next one is writ of prohibition. This writ is issued by a higher court against lower court, tribunal and other quasi-judicial authorities from doing something beyond their authority. It is issued when the lower court or tribunal acts without or in excess of jurisdiction or in violation of rules of natural justice or in contravention of fundamental rights. It can also be issued when a lower court or tribunal acts under a law that is itself is a ultra vires. In other words, the object of the writ is to compel lower courts to keep themselves within limits of the jurisdiction. While mandamus commands activity, prohibition commands inactivity. While mandamus is available not only against judicial authorities, but prohibition is issued only against judicial or quasi-judicial authorities. Writ of prohibition is not available against administrative authorities, legislative bodies and private individuals. The difference between the writ of certiorari and prohibition is that they are issued at different stages of proceedings of the case. The writ of certiorari is issued after the case is heard and decided to squash the decision or order of a lower court when the lower court passed an order without or in excess of jurisdiction, whereas the writ of prohibition is issued prohibiting the proceedings in the lower court which acts without or in excess of jurisdiction while the case is pending before it. Student, I have discussed all fundamental rights which are guaranteed against state and confirmed under Part 3rd of Indian Constitution. Now let us come to criticism of fundamental rights. Fundamental rights reflect the independent and individualist oriented ideas of our freedom fighters and constitution makers. Since these rights are legal, coercive, negative and unencroachable, the Act is a means for promoting the personality of individual citizens and for curbing the despotism of the government. In spite of their meritorious nature and significance, these rights have been criticized by many scholars on several grounds. Fundamental rights granted by the Constitution have been hedged by many restrictions and limitations that they virtually become ineffective. These limitations limitations have the effect of depriving the rights in all reality. One of the critics suggested that the chapter on fundamental right should be renamed as limitations of fundamental rights. However, the very circumstances in which our country got freedom emphasizes the need to spell out restrictions. The second criticism leveled against fundamental right is the remedies provided for protection of fundamental rights are very expansive and beyond the capacity of common man. As a result, only the rich people can seek legal protection against violation of their fundamental rights. Thus, the critics feel that the right benefits only a few in the country, mainly the rich. The majority poor are unable to fight for their rights. However, recently, with the public interest litigation and the establishment of legal aid for the poor, this gap between the poor and rich is being sought to be reduced. It is criticized that our constitution mentions only a few fundamental rights. Other rights such as the right to work, the right to employment, etc. were not included in the list of fundamental rights. The language used in this regard to the explanation of fundamental rights is beyond the comprehension of the common man. Even the eminent lawyers and judges face difficulty in analyzing and interpreting some provisions relating to the fundamental rights. So, it is aptly described, the Indian Constitution is a paradise for lawyers. The making and implementation of certain laws relating to preventive detention, national security, maintenance of internal security, etc. totally negates individual liberty. Thus, some writers rightly described that our constitution gives fundamental rights with one hand and with the other hand takes them away. But they also state that such exceptions and limitations are necessary in the larger interest of the nation. In spite of the criticism, fundamental rights are considered as jewel of our constitution. The progress of a state depends not only on the implementation of welfare state scheme but on the enjoyment of fundamental rights. The constitution expert M.E. Bailey describes that the chapter on fundamental rights remains a formidable bulwark of individual liberty and a strong and sustained basis of Indian democracy. Student, I hope that you understood the concept I have discussed in this class, that is constitutional remedies guaranteed under Article 32, that is writ of habeas corpus, writ of mandamus, writ of certiorari and writ of prohibition, etc. And finally, the criticism leveled against the fundamental rights. Thank you.